Everybody, welcome to the call. My name's Andrew Schiestel, and I'm the Chief of WOW Projects at TBK Creative. TBK Creative is a national award-winning web design and social media marketing agency. Today's talk is email marketing and the law, tips to succeed in a tougher legal landscape. I'm going to be joined in a moment with David Canton, a business lawyer and expert on this topic. Before I invite David to join me, I'm going to give you a little bit more background on who David is. David Canton is with the law firm Harrison Pence. Harrison Pence is one of London's largest law firms. David is a business lawyer and trademark agent with a practice that focuses very heavily on technology issues and technology companies. He advises on such matters as social media law, information technology, e-business matters, software licenses, et cetera, et cetera. David's also an author and writer. He's a published author in that he was a co-author of a McGraw-Hill, publisher McGraw-Hill book back in 2002 called Legal Landmines in E-Commerce. And David's also a regular columnist with the Free Press, with the London Free Press. That title of that column is called Tech Watch. Aside from law, David sits on the board of directors of Orchestra London, and he's also a past director of the London Chamber of Commerce. Through the magazine, the Lawyer Weekly, or the Lawyers Weekly rather, David was listed as one of Canada's top legal social media influencers. Quite an impressive list to make. And this summer, this really speaks into his credibility in the legal circles on this topic. This summer, David has been asked to moderate a major Toronto law conference hosted by IT Canada and the Law Society on the topic of privacy and anti-spam. So on like a national perspective, David would be considered one of the foremost authorities on this very topic. So we were excited to have him on the call. And on a personal level, if you registered for the webinar previous to today, you would have got an email from me this morning, and I shared a little anecdote with everybody. And this is the real things that from the agency perspective that I see with email marketing and why I'm really passionate about this topic. And if you just registered today, I know a bunch of you did just register today. I'll just reshare the anecdote. We had a client, kind of a small, medium-sized client here in the local area, start email marketing for the first time last December, and they were about an $8 million a year business, but they were trying it for the first time, and over the years they had built up a database of over 12,000 emails, so which is good for their size. They're an older company, and so we went through with them and thought about the promotion and the offer. We crafted the design for the email. We set them up on MailChimp, and we pressed the button, and it published, and the email went out. That one email alone for this company translated into 97 sales, totaling over $17,000 in revenue. And when we did the ROI calculation, it came out to over 1,300%, and that was with only one email. And in this case, this was actually a company that over the years, these were actual customers of theirs that they had built up. And David's really going to dive into a lot of this content here. But back in 2010, I think that's the correct year, there was some new legislation passed. And the effects of that legislation is going to start to take hold and take effect as early as this year. And so, as a marketer, something that I do not want to see taken away from myself, and I know everybody on this call, because you're all marketers, is the ability to correspond still in a commercial way through email. And so that's really why I wanted to host this call today. And I wanted to bring on David Canton, who is a true expert in this area, to speak more about what this legislation is, what it means for your business, and how we all as business owners or entrepreneurs or marketing directors, marketing coordinators can begin to prepare for that legislation. So with that said, what I'll do now is pass the controls over to David, because I know he has a PowerPoint that he's going to work from. So welcome to the call, David.
Thanks, Andrew.
Yeah, you're welcome. Coincidentally, as I'm just passing over controls, David, what triggered this for me to reach out to you was the fact that, if you remember this, you actually sent me an email about the law.
Yes,
You remember that?
I remember that. Yes,
Yeah. I guess the irony in it all, right? So David wrote a really good 5-part series. I'm sure at some point in the call, David, feel free to mention where people can find that at some point
right.
in the call. But David did write a really good 5-part blog series on this new law that I encourage everybody to read. And you emailed me about it, and that's what got me thinking. This is really important information. We need to get it out there.
Okay.
Did you get the
Uh,
controls okay for your
I think I do. If everybody can see the Anti-Spam Act slide, we're set to go here. Okay. Well, thanks, Andrew, for that kind introduction, and thanks everybody for joining us today. What I'm going to do in the next little while is I'm going to give you an overview of the Anti-Spam Act, talk a little bit about the penalties under the Act, which is why you need to care about it, talk about what spam is and is not, and give you some ideas about what you can start to do now to get ready for the legislation. So the Anti-Spam Act was passed in 2010. We're expecting it to come in force sometime later this year. And if you think it won't affect you because, excuse me, because you don't send mass emails, well, you're probably wrong. We're all send emails out that would violate this act. My personal view is that the act's fundamentally flawed. It does have tools to combat spam, but it defines as spam things that most of us would consider fairly innocuous and perhaps desirable. So it's going to be a real compliance headache. And the act is quite long and complex. The first indication that the act's overly complex is its name, which is up on the slide here now. You will hear people call this the Anti-Spam Act. Another thing you will hear people call it is CASL, or just give me a second here.
Yes, okay.
There we go.
Is that really sorry, Dave, is that really the name, like, out of all the names they could have officially called it, is that really what it's called?
This is really what it's called. And most statutes have a long name and then a short name. This one doesn't have a short name. So technically, this is the name, and that's why you will hear it called by different names, such as the Anti-Spam Act and CASL, or CASL, for Canada's anti-spam legislation. That seems to be a popular one as well.
Okay.
So essentially, it applies to the sending of commercial electronic messages. So any kind of electronic message with any kind of commercial purpose is caught. But there is a whole complex set of exceptions and consent requirements. And a lot of the details required to understand the daily impact are contained in some regulations which come from 2 different government departments. There's some from the CRTC, and those are already in place, or have already been passed. And they talk about the issues surrounding information to be disclosed and what consents, or how you have to get consent from people to send these. Industry Canada regulations are still just in draft form. They are in draft because the first version contained a lot of criticism. So the second draft came out in January, and there was, again, a lot of commentary on those. And so they're looking at those again. And there's, so once the Industry Canada regulations are finalized, they will publish those, and at that point they'll tell us when it's coming into effect. Like I said, the best guess at this point is sometime later in 2013. Although there's some that think maybe not to 2014, but we just don't know yet. One thing to keep in mind is that um, I'm going to talk in terms of email probably here just for ease of reference, but it applies to commercial electronic messages as it's defined. And that includes not only email, but also instant messages and social media to the extent, at least in my personal viewpoint and that of some others, it's, for example, on Twitter, if you do a tweet, it's not caught, but if I direct message someone using Twitter, it probably is caught under the ambit of the legislation.
Mm-hmm.
So the penalties under the Act are quite significant for noncompliance, and they're also quite detailed. Remedies include fines of up to $1 million for individuals and up to $10 million for businesses. It also includes private rights of action, and which is kind of what scares me a little bit, because what that means is if I send one of you an email that you believe is spam, you can sue me for it. And it also contemplates class actions. So if I send an email to several people and there's a thought that it's spam, I'm facing a potential class action. And you don't have to prove damages. It includes what's called statutory damages. So unlike most lawsuits, you don't have to prove that you were harmed. You just follow the formula in the Act. And why that concerns me so much is that it's easy to sit back and say, well, the CRTC, which is the body that's going to enforce this, isn't going to be, they've got this big office they've set up somewhere in Ottawa. Think of them as the spam police. Yes, they're going to be going after the large spammers, the people that you and I would all consider spammers, that send out by the millions emails trying to sell us all kinds of weird and wonderful products. And they're not going to be looking for you and I when we send a few emails out. But because this private right of action is in there, you can't just sit back and say, oh well, the CRTC isn't going to bother me. There's also some things that are what's called reviewable conduct, meaning that the privacy commissioner in some cases, or the competition commissioners, are able to do an investigation, and they can actually order us to do certain things and behave differently. And if we ignore those orders, it's sort of like getting an injunction from a court. So if we ignore those, then we're in trouble. Another thing in the penalties that's kind of concerning is that directors and officers can be personally liable if they authorized or acquiesced in the offense. I think what we're going to see is many corporate and charitable boards are going to have to mandate some sort of anti-spam policies and procedures to take advantage of due diligence defenses so that the directors aren't found personally liable for what their companies do.
Sorry, David.
Yes, go ahead.
Yeah, just to expand on that for a moment. So, are you saying that there may be protection under the law, or are you saying there may not be protection under the law for directors of corporations that may violate this new legislation?
Yes, it doesn't affect the fact that the corporation is liable if their employees violate the Act, but directors and officers are only liable if they either authorized, meaning they told the company to do it, or they acquiesced in it. Acquiesced, kind of unclear what that means, but essentially, if there's a board policy passed that says, we won't tolerate violations of this act, and you can't do that, and this sort of thing, then that certainly helps the directors.
Okay, so I think that's probably important for probably everybody listening to the call. That
Yes.
Whether you own companies, I know there are some people here that are, and I know there's some directors here on the call. I know there's some marketing managers and coordinators on the call. If you're a marketing coordinator or manager, this may be something you want to pass up to your C level, because it sounds like it's relevant. And then
Yes, definitely.
yeah, and if you're at that, if you are a director, then that's something that you need to take very seriously as well. There could be some
Right.
things, it sounds like, that needs to be passed at a board level.
Yeah, absolutely.
Okay.
So let's talk about what spam is. And it gets pretty complicated. I'll give you the highlights here. The articles I've written go into it in a little more detail, and there's also a chart that I've put together, and I'll tell you at the end where to get those, that helps you kind of walk through it a bit. So the first question is whether it's a commercial electronic message, and that is fairly broadly defined. Um, Electronic message, as I said, is fairly broadly defined to include email and text messages and various other things. Um, and it's deemed to be a commercial electronic message, and read that to mean spam, if it's having regard to the content of the message itself, or if you're putting links into it, the contents of this place you've linked to, that it would be reasonable to conclude has one of its purposes to encourage participation in a commercial activity. And commercial activity is broadly defined as well. To paraphrase it, it's any act of conduct that's of a commercial character, whether or not there's an expectation of profit. So if you're not sending what's a commercial electronic message, and it's not spam, and the act doesn't apply. So if I send an email or whatever to one of you saying, um, hi, how's the weather today? And there's no links in there to anything that might be considered commercial, then it's not spam. Now, the catch is that the CRTC, in a webinar they did, have said that a mere link to a commercial website is enough to say it's partly commercial purpose. So that's it doesn't take much to pass the threshold. So if you're not sending, okay, like I said, if you're not sending a commercial electronic message, it's not spam, the act doesn't apply. If it does meet the test, then you have to ask whether it's sent to a person that you have some sort of a personal and family relationship with, and it actually takes in, as we can, a whole page to define what that means. Or if it's an inquiry relating to the recipient's commercial activity. So if one of you sends me an email and said, David, can you tell me more about how to apply for a trademark, that's not considered spam. But even if none of those work, there's a long list of possible exceptions, and they include things like requested quote. So if I send you an email and say, how much would you charge to do this for me, your reply is not spam. Facilitation of some commercial transaction that we're already into. There's some exceptions for warranty and recall information. Delivery of products or upgrades that you're entitled to, some things like that. And if the message doesn't fall into any of these exceptions, and if the sender doesn't otherwise have some explicit consent from the recipient, then it's just spam and you just can't send it. Now, if you have consent, and consent can be implied or it can be explicit. So explicit consent is somehow you told me that yes, it's okay if you send me emails about future webinars or future products or something, then that's explicit consent. There's also a long list of things for implied consent, and that's things like an existing business or non-business relationship between the sender and the recipient. And again, these are things that are defined at great length in the Act and in the regulations. One that's very interesting is if it's to someone who's published their address without stating they don't want to receive unsolicited commercial electronic messages, but that's only provided the message is relevant to the recipient's business. So, for example, like most lawyers, I've got my email address on my profile on my website and on my blog. And so, since I've done that, I've published my email address, and I haven't said, don't send me unsolicited stuff, then it's not considered spam if you send me an email that's relevant to my business. Now, that's a bit unclear what that is. Clearly, if you're trying to sell me a timeshare in Florida, that's not relevant to my business. But it's got to be something more than just inquiring about my services, because that's always subject to another exception. So, whether if you want to sell me pens and paper or printers to use in my practice, whether that's relevant to the business is a bit unclear, but that's there. Another one is if you've disclosed your address to the sender in another way. So if I had met Andrew for the first time at a networking event and we exchanged business cards, if one of us doesn't say, "Don't spam me," when we do that, then sending an email to each other is not considered spam.
Okay. Okay. And therefore, inside of this new legislation, that would be okay.
Yes, that's right.
Okay.
And it shows one of the problems with the legislation is it's just too darn complicated. The
Hmm.
analysis that you have to go through in any given situation is rather daunting. Um, but so let's say you've got to this situation where you said, okay, I've got either I fall within some of these exceptions, I've got express consent or I've got implied consent. You're not quite out of the woods yet, because you can only send a message if it conforms to requirements contained in the regulations and identifies the sender, has contact information, and an unsubscribe mechanism. So in essence, what that's trying to do is to say, to make it clear that if I'm sending you that email, that it has to be very clear that it's me sending it. I can't spoof somebody else. I have to tell you my contact information, and I have to be able to, and you have to be able to unsubscribe and say, David, don't send me any more emails about webinars anymore. And I have to be able to track all that stuff too, which is a real head scratcher, because the Act doesn't explicitly say I have to track it, but it explicitly puts the onus on the sender to prove it, which kind of means you have to be able to prove that you have these consents in place.
David,
Yes.
you and I meet at an event. You give me your Harrison Pence business card,
Yeah.
and I give you my business card. You email me and say, really great chatting with you, Andrew, about contract agreements at the Business After 5 last week. Do you want to get together for coffee next week and keep chatting? Does that, inside this new law, if and when it gets enforceable, do you have to have an unsubscribe mechanism in that general email to me? Or I guess general is not the best term, more personal email to me.
Um, yeah, you might have to. It's kind of yeah. It sounds kind of weird, doesn't it? Yeah, yeah. It does sound kind of weird.
Yeah.
Um, and we're still trying. We're still scratching our heads on that a bit. And are we actually in a place? Because I think of spam as something that's sent out like thousands at a time. And they haven't put an exemption in it that says, if you send a one-off or send it to less than 10 people, it's not spam, which is, to me, is a big flaw. But, you know, um, so you tend to start to scratch your head and you go, okay, so do I have to just have an unsubscribe mechanism just in my standard email footer? But then that doesn't make sense either, because you're sending emails out that aren't spam, and you don't want to have people to think they can unsubscribe to something that you don't want them to unsubscribe to. So it's going to be kind of a head scratcher along the way.
Sandy asked this. She heard that let me just pull up her specific question here. Sandy on the call. She's heard that from one of her colleagues in Ottawa that some of the aspects of the legislation are under review. And so I think what she's wanted to know is there a chance that parts of this law is still going to get re-looked at, or are we at a stage now that it's inevitable that this legislation is going to be enforceable as
Yeah.
we know it today? What stage are we at with all this?
Yeah. Well, the act itself it's passed. I mean, it is what it is. What's the outstanding part right now are the finalization of the Industry Canada regulations, and those regulations that are out there are partly the regulations that sort of water down, if you would, the not the definition of spam, but um, who they can be sent to and the implied consent stuff. So there is, frankly, there's a lot of um, people complaining about this thing,
Mm-hmm.
but the government seems fairly determined to get this in place. They've already spent a fortune putting this anti-spam police office in place. I think the most we can hope for is that there might be maybe the Industry Canada regs that are being finalized will soften a few aspects of this. But if you had to ask me what the odds are that this thing is not coming in force, I would say those odds are slim.
Okay.
Um, Now, while we're on the topic, it just as an aside, some legal commentators have said that um, based on a Supreme Court of Canada case on the national securities regulator attempt, that um, at some point somebody may take a run at this legislation and say it's outside the jurisdiction of the federal government to do it. So that could be interesting, but
Mm-hmm.
that's going to, if somebody does that, it's going to take a while to wind its way through.
Okay. And just as an
And
aside, for everybody as well as we're going along here, David and I are planning about 10 to 15 minutes of Q&A at the end. So feel free. I just have a sense there's everybody on the call has a few questions. So feel free if there's something that's really burning, go ahead and ask the question. I'll either pass it on to David if it really progresses the point that he's making, or I'm going, or second, I'll wait till the end of the call and put in the Q&A. Third, if we don't have time to get to it, I'll speak to David about the questions afterwards, and we'll just figure out together what the best way to answer some of those questions for you is. But I wanted to bring that up because I didn't bring that up at the start. So feel free to ask questions through the filter.
and one more thing I want to comment on before I move on to some other things in the Act is that I don't know if any of you on the call are charities or on charitable boards, but there's a real problem or uncertainty right now as to how far it will impact charities. And I think there's a fairly broad interpretation of commercial activity, and an indication of that is they actually define implied consent to include references to volunteers and donors. Um, so, it's unclear at the moment whether, um, for example, Andrew said I'm on the board of Orchestra London. So if an orchestra sends out an email to existing donors and says, "Oh, you donated before. Would you like to donate again?" And assuming they don't fit within, there's a 2-year rule that I'll mention in a bit, but assuming they don't fit within these rules, is that spam? Is that a commercial purpose? Same thing if you send an email out saying, you volunteered as a volunteer usher before. Would you like to do that again? Is that a commercial purpose, and does that fall under it? So charities have been complaining about this. There's a scintilla of hope that the Industry Canada regulations might help with that, but we don't know yet. Now I know the focus here is on email. I want to spend just a very short minute or two here telling you about some other things in the Act, because people are not aware of some of these other things. Mm-hmm. It has some anti-spyware provisions. The goal is being to eliminate spyware and other malicious software. In essence, for any software that's being installed on someone's computer, there is a protocol in place where you have to get some specific consent from the owner to do it, and it has to be outside of the end user license agreement. So if there's software being installed that might do certain things, then you have to get this explicit consent before it's installed. And the definition of computer program and computer system is very broad. And the way I read it, it could include software installed on our smartphones and ebook readers. And the thing that is quite bizarre is everything we own has some kind of computing power, even PVRs in cars. So does it apply to that as well? That's a bit unclear.
Okay.
So if, probably none of you are in the software business, but those who are going to have to think about that. There's also telecommunication service providers, meaning internet service providers. There are preservation demand orders there. So if there's an investigation, the CRTC can go to, if there's an investigation against you and you use Rogers as your ISP to send this stuff out, the CRTC can go to Rogers and say, we need you to preserve the transmission data for 21 days from that person so that they can do their investigations. There's also some amendments to the privacy legislation, or PIPEDA, to make it a privacy breach to harvest email addresses by electronic means. And there's also been some new deceptive marketing practices added to the Competition Act. These are the false advertising things. And it includes things like sending false or misleading representations in the sender information of the subject matter of an electronic message, or sending or causing to be made a false or misleading representation in a locator, which means if I misstate my domain name, and that's a favorite spammer thing. If you get spam and you want, one telltale thing of getting spam email, if you're not sure, is just to hover your mouse over a link, and the odds are good that that link may go to someplace else other than where it looks.
Mm-hmm. Mm-hmm.
So what can you do now to start to prepare? As I said, it's a bit unclear when the act's going to come into force. Let's assume it's later this year. And I guess the first thing to comment on is consent is king under the act. So you should be thinking about now about how to best obtain and document consent to send electronic messages. So if you can get, and we have, I think in my mind, I put this in two different things. There's the sort of the mass email that gets sent out, such as what Andrew sent out about this webinar. There's that kind of email. And then there's sort of the one-off emails that any of us would send to, one person.
Mm-hmm.
And you have to kind of think of those. They fall under the act in the same way, which I think is wrong, but you have to kind of think of them a bit differently. And how are you going to get consent for that? One kind of bizarre thing is if you now have consent to email people under PIPEDA, the privacy legislation, it may not qualify as consent under the Act. You may have to get consent again because the levels or the threshold for consent under PIPEDA is less than the threshold for consent under the AntiSpam Act. Now, the CRTC is saying that you can't do opt-out, you have to do opt-in. I don't think the Act says that, but the CRTC is enforcing it, so that's probably not an argument that you hope someone else is going to have with them, not you. The other...
Sorry, David. Sorry, David. Can I bring up something about the opt-in piece? Because I think that's going to be really relevant for probably almost everybody on the call. So I have a couple questions probably on behalf of some people on the call that have websites. Sure. So my first question is if a brand on a website here is doing a sweepstakes campaign and they're collecting people's information and at some point the sender is going to be clicking, submit my information. It could be a sweepstakes, it could be whatever, it could be contact us form. But as I see it, there's three sort of broad ways of gaining consent in the past. The first way is you just put it inside of some type of terms. So you just say, by submitting your information, we can send you promo material.
Right.
Some kind of lingo like that. That's one way. Another way is that you have a checkbox that is unchecked, and the person needs to actually check it before sending it. So like a true opt-in. They are choosing in that moment to click, and then we're clicking send. And then the third way is that I've seen in the past is that same checkbox is there on the form, but it's checked already for the user, and they would have to uncheck it to proceed. Under this new law, which way is, first of all, which way must you do, if there's a different answer to this, what way would you advise people to do?
Right. Okay. Yeah, bearing it in terms of use isn't good enough. They talk about having a positive step, and the CRTC actually put out some explanatory material and how they're interpreting it, and they specifically said that what they call toggling, which is unchecking a box that's pre-checked
Mm-hmm.
to opt out, is not allowed. So, and again, that's something I don't think the legislation supports that, but that's the interpretation that they're saying. So, the right way to do it is have some sort of positive step where it basically is very clear um, um, what you're doing. Now, the preferred route for the they talk about is a checkbox that you go in and click and check that and say, yes, please send me this. Now, I can't imagine that if it's very, very clear that some very clear language that says by sending this or by returning this, you're agreeing to to get these emails. I can't imagine that that's not a positive step because you've taken the positive step to do that. But again, it's a bit unclear at this point.
Yeah. Do you find that okay? So let me try to reiterate what you're saying, and tell me if I'm correct or if I did not understand you correctly. Are you so you're saying that the act in your interpretation right now is that it's a little bit too broad to know for sure which of those three ways um, you must do. You need some kind of positive way though to gain that kind of consent, and that advisably the safest way is to keep it unchecked and to have somebody check it off. But if you were to do one of the other two ways, it might be in compliance, but there's still room for interpretation. Is that what you're saying?
Well, yeah, I wouldn't quite put it. Yeah, that's fair, except that clearly bearing it in your terms is not does not work. The CRTC has said this unchecking, in their view, in their interpretation of it, and they're the ones that are enforcing this, is not acceptable. So, until somebody takes them to task and they either change their mind or a court says no, that's not the interpretation, that's pretty much the safe way to go. Um, it's all about the positive step. So
Yes.
the key is to make it has to be clear what you're agreeing to, and you have to take an actual step to make it happen.
Okay, so you're saying CRTC stance is that having a box checked right now and forcing somebody to uncheck it to proceed would not be a true opt-in
That's
under the
Yes,
legislation.
that is the CRTC's
Gotcha.
official view on it. Just as an aside, it's kind of interesting because under privacy, the Privacy Commissioner doesn't like opt-out consent, but they will go along with it if it's done in certain ways, particularly if it's at the outset. But the CRTC, at least in a seminar that I heard them put on, they think that the Privacy Commissioner refuses opt-in or opt-out, and so they say, well, we want to do the same. So there's some really mixed messages getting through from the various regulators.
Okay. All right.
So
So to summarize that, it's advisable based on where CRTC's stance is that when this comes into effect and is enforceable, is to have that positive step, which is keeping the checkbox unchecked and allowing that person to check it if they wish to receive regular promotional material from the company.
yeah, absolutely.
Gotcha.
So essentially, to prepare now, and we want to get to the Q&A, so I'll fly through the rest of this pretty quickly. But you should be looking now at um, your, but basically auditing your information practices. Take a look at the types of electronic messages you send, how you send them, who you send them to, how you got their email addresses, and whether or not you might need consent. And then as sort of a picture of your electronic communications emerges, then you have to sort of think about how does it fit in the act. Would they qualify as spam? Do you have consent? What information do you need to add to the communications? And that sort of thing. One of the things we're going to see, I think, before the act comes into force, is a huge groundswell of emails coming out to us asking us to consent to various things. Because once the act is enforced, I can't email you to ask to get your consent to do something. That email to ask for consent is considered spam.
All right, great tip.
So yeah, there's going to be and the problem is right now, until we get the final Industry Canada regulations, some of these things are a bit unclear. So I think there's going to be a huge amount of activity between the time the Industry Canada regulations are final and between the time the legislation comes into force to try and get consents in any way you can. Those consents will have to be consistent with the Act, but you're not saddled with the you can't email for a consent issue.
David, how does it work timing-wise then? So when these regulations are published, I
Yes.
assume the regulations will spell out the do's and don'ts.
Yeah.
When that gets published, will that now automatically, what is being published, will that now automatically be in force? Will that be forced, or will there still be a window of time in which businesses can now read that, understand it, and then take action accordingly to prepare themselves?
Yeah. There will be a window of time. What the expectation is that the Industry Canada regulations will be published, and when they are published, it should say, basically, it should say, okay, here's the final regulations. The act and these regulations will come into force on this date. And, my estimation is that that time will be measured in, I don't know, let's say 3 months or something like that. It's not going to be days. It's not going to be years, but there will be some time because to just kind of get your acting gear. Um, One other thing is if you use any third-party mail services to send emails to customers, you have to make sure that they're implementing processes to comply. It's still your responsibility, but they have to. We're going to have some issues that if you use American emailers, they're not going to be familiar with this, and they may have issues. They may say they're not going to do it. You may have to find someone in Canada. Whatever, but that's going to be an issue. And if you rely on third-party providers to provide you with mail lists, email lists for people, you're going to have to make sure that somehow their lists have opt-in. That's going to be kind of tricky. I don't know how that's going to work, but you can't just buy an email list from anybody anymore. So, and very briefly before we get into the Q&A, some challenges going forward. We talked about the toggling, getting that figured out. We talked about a deluge of emails to try and get permission. I'm going to just give you one example to kind of put this in context. Let's say an example of buying a car. So let's say I go in and I buy a car, and let's say that I don't sign express consent for future communications. Let's just say that that's not even, they haven't done that. So there's a rule in the definition of an existing business relationship that says if you have an existing business relationship, there's an implied consent for 2 years following the latest transaction. So I buy a car today, so the 2-year rule kicks in. Well, if I buy the car, so that's 2 years from today, but if I lease it, does that 2 years kick in when the lease is over because it's an ongoing transaction? So does the fact that the lease is with a financial institution rather than the dealer means that the finance company's 2-year period starts when the lease expires, but the car dealer's period starts when they buy the car? And Or does the 2-year period of the dealer start to run again every time I bring the car in for service? Or does that just apply to communications regarding the service and not to communications relating to a new car? So it gets kind of really bizarre to try and figure that out. And I'm hoping that as we get into this, some of these things are answered a bit, but it it's certainly not um, clear. Some of the issues to ponder, just to finish up here, um, one of the key issues would be to figure out the boundaries of commercial activity. And like I said, the specific provisions relating to volunteers and donors for charities suggest to me that commercial activity may have a broader definition than you might think. Um, Also consider what the ramifications of the Act are in an era of convergence when messaging platforms are merging and mobile access to content and location-based content is becoming more prevalent. Um, and there's how strictly will the Competition Act misleading advertising provisions be interpreted? For example, will an email subject line be just judged on its own or in conjunction with the broader details in the message body? So I think that sort of covers it in a very high level as best as we can. And we've still got a few minutes for questions. Going forward, you can read my article series that's on my blog at illegal.ca. The address is there. You can start thinking about a message audit and analysis to try and figure out what messaging you do, and think about getting compliant consents now, or at least when the Industry Canada regulations are finalized, so that you can have a slightly easier time of it once the Act comes into force.
Mm-hmm. Mm-hmm.
So, Andrew, I'll turn it over to you for any questions that there may be.
Yeah, we have a bunch here. Really good material, David. Donnie has a question. Okay, and this may tie into the 2-year from last purchase, but I think reiterating it would be very, very useful for all of us. So what Donnie's asking, David, is if someone buys or attends a training from your company, would
Okay.
that at that point be considered implied permission? And can his company at that point contact that person for future related trainings?
Um, yes, I would say so. You have to answer these questions, you have to dig into the definition of existing business relationship, which is covered both in the Act itself and in the regulations. You have to take those situations and walk through their definitions and analysis. But that's the kind of thing that I would think would start the 2-year clock running.
Mm-hmm. And can you clarify that 2-year clock, just so it's really out there for everybody, David? Are you saying that from the time someone purchases a product, we can, as marketers, send that person solicitation, commercial communication for up until 2 years, and after 2 years, we can no longer send them commercial communication? Is that correct?
That's correct. Unless they've opted in or they've done something to, if they buy something new from you or something like that. Also, the other thing to keep in mind is um, a a positive opt-out trumps that implied. So
Gotcha.
if I buy something from you today and you start sending me stuff based on that implied, that 2-year rule, if at any time I say, Andrew, stop sending me that, you have to stop sending me that or it's a violation.
Yeah. Okay. I'm getting it's getting clearer for me. And so the other side of that though is if somebody hasn't bought a product but they have explicitly opted in,
Yes.
you can now send them commercial um, communication. If it's in a mass email type setting, you need to give them an ability to opt out, is what you're saying, right? Uh,
Yeah.
and then there's no time limit, so there is no two-rule time limit according to this legislation, unless at some point they opt out. Is that correct?
Yeah, that's essentially correct, and that's why I said consent is king. So,
Yeah.
once you get somebody's consent, and you have to be careful because you have to figure out what they've consented to. So drafting those has to be, you're going to have to be, we're going to be careful how we draft those things. They have to be very clear. And of course, everybody's going to want them as broad as they can. But yeah, if you get someone's explicit consent, until they revoke that, that consent applies to you. You don't have to worry about any of this other stuff. Although, if it is considered a commercial electronic message, then you may still have to have that opt-out, unsubscribe stuff in it, which is going to be, and that thankfully they've said that let's say the direct message or text message thing, which only has so many characters. Thankfully they've said that you can link to it. I don't know how you do it otherwise.
Right, right. As SMS becomes more popular in some of marketing.
Well, and to show how they haven't thought this through, on that CRTC seminar that I mentioned, someone asked them about social media, and they hadn't really thought about it too much. They kind of went, well, we're really thinking in terms of email and text messages, but gee, I guess it could apply to that. Well, to me, it very clearly applies for it in the way it's defined. And again, it's not if I tweet to the world or if I put a Facebook message or a LinkedIn message for everybody to see, but if I send a direct message or a targeted message to one person, then I fall into the definition of commercial electronic message.
It's a good point, because I'm just thinking of like the LinkedIn environment, for example. You can either send messages to your contacts, in which case somebody could disconnect with you on LinkedIn. I'm just kind of thinking this through. You can also pay for credits in LinkedIn to be able to message somebody who you may not be connected with. But I'm not sure. I suppose maybe I don't remember within the LinkedIn environment. I know Facebook has this, but if there's a blocked button, if you can block a message, do you think that would be sufficient for somewhat opting out? You see, to kind of get where I'm going with this, to tie it together.
Yeah, I'm not sure about that, because that if you're blocking it using the mechanism that you're sending it, that block doesn't get back to you as a sender, so you're not going to know they blocked it or opted out.
Yeah. Okay. All right. Let's leave it like that. It sounds like there's some gap. There's just some natural gaps that still need to be thought through here.
Absolutely.
Yeah. Okay. Simon has a question. Simon works for a municipality here in Canada. He has a rather large distribution list within the municipality for press releases. So I assume these are different media groups. He says many have signed up years ago. He wants to know if those would be grandfathered into this new law, and if not, what are they to do?
Yeah, the existing consents may very well be grandfathered in, and what you have to do is kind of look at, and unfortunately, we have a disconnect between the CRTC and Industry Canada on that issue. One of them says one thing and another one says another. So the two government departments enforcing this can't even agree on this issue. So, I guess what you have to do is look at how those consents were obtained, and if it's a fairly clear consent to it, then you're probably okay. But you may have to go out and get consent again, and it's going to be frustrating, and we're going to have to, in each one of these situations, we're going to have to sort of walk through the act, because in practice, the problem is that people tend not to opt in, and what you would get in that situation is, people are getting these emails and expecting to get them, and then as you send the emails out, already you may ask for a positive consent to keep getting it under the new legislation, and you can guarantee that large quantities of people won't pay any attention to that, won't bother to check yes, and then after and then they'll stop getting it, and then they'll complain. Well, why am I not getting this? Well, you had 5 opportunities to opt in, and you didn't, so we didn't have a choice. And we saw this happen with privacy consents under PIPEDA when that first came in a few years ago. Some of the banks, for example, would send out all kinds of stuff they'd send out separate brochures, they'd send out flyers in their statements, they do all kinds of stuff so that every customer had at least 5 or 6 contacts telling them about privacy policies. And there's no way you should have been able to miss that, but they still had all kinds of people that even after that professed not to have any clue what was going on. So yeah, it's going to be difficult.
Okay. I'm going to close up the webinar right now for the sake of time, so that we can end on time. This was a really hot topic, and I found this personally very informative. David, I thank you for being on the call.
Thanks, Andrew.
Yeah, and on behalf of everybody, I just thank you for taking the time to share your knowledge. There are a lot of questions that just for this, because of time, we cannot get to.
Right.
And so, like, I just want to acknowledge that for everybody as I see your questions. I will chat with David after the call when we can both connect again, and we'll just chat about like what we could do with some of these questions. I don't know what we'll do yet, but I just want to acknowledge it for everybody as I still see your questions, and there's a lot of really good questions there. But I do want to end the call on time. So thank you everybody for being on the call. David, can you tell everybody quickly again how they could reach out to you if they need to?
Yes, you can. I will be publishing more. excuse me. excuse me. More things as they develop on the illegal.ca blog. Also on the final screen there's my email address is there, and phone number. Great. And web address. So it's all on your screen that you're looking at right now.
Okay. David, you want to do this this type of call again in the future?
Absolutely.
Yeah, like I'm thinking about at some point when some of this stuff takes hold again. I think it might be useful to connect again and offer this kind of webinar material again.
Yeah, it might be a good thing to do it once the Industry Canada regulations are finalized, and we can give a little bit more concrete advice, hopefully, on some of these things.
All right, good. So don't opt out of my emails, everybody, so that you can see that email come to you. All right, so everybody, I know that you probably want to listen to this again. There's a lot of material here that you want to pass over to your companies and executives, your team members, etc. So within 7 days, go to tbkcreative.com/blog. We're going to get this thing up in YouTube, and we'll embed it into a blog article for you guys, so you can see the slides and you can re-listen to all the material and share it with everybody. David never asked me to say this, but I just the legal side of me, and I'm not a lawyer, but the non-liability side of me says that I should say this. Material today was educational content only. so no coming after me or David if something we said here was inaccurate, although I do trust what David has to say. I just recommend, for the sake of you guys, because I personally I know David wasn't able to hear your individual situations and have the fullest perspective. So as you're making decisions that will really matter, as you make these decisions, make sure that you are seeking the proper legal advice so that you have your backs and your corporate backs covered. Thank you, everybody, for being on the call today. Hope you enjoyed all the material, and have a great rest of your afternoon. Bye for now.